We have been very proud to be able to provide the forum for the Federal Bar Association Diversity and Inclusion Committee's four-part series. And if you've been with us for the 4 parts, we've been talking about the history of the Voting Rights Act, Section 2 and Section 5 of the Voting Rights Act, vote dilution, recent developments in the law, including recent oral arguments in the Supreme Court. And we end this series with a discussion of not just exercising your right to vote and possibly having that vote diluted, but actually not being able to exercise that right to vote. And that is in terms of when folks have a felony conviction and what the effect of that felony conviction is on the right to vote. And I was looking up some statistics, and the last statistics I saw, which may or may not be correct, was that just over 6 million Americans are not able to exercise their right to vote because of their criminal history. So it's very exciting to have this discussion. It certainly is a timely discussion when we certainly know every vote counts, given the special election that we just heard about yesterday. And I think there's about 650 votes that separates who is going to be the elected representative in that district. So I'm very proud to open up the discussion. I'm going to turn it over to Ami Gandhi, who will be the moderator for today's event. So sit tight, and I'm sure we're going to hear a lot of interesting things. Thank you.
Thank you. Before we start, actually, I wanted to request if we can hear a little bit about Seventh Circuit Bar Association and any updates that you have, Margot.
Sure. Hi, everyone. Thanks for coming. On behalf of the Seventh Circuit Bar Association, we welcome you. We want you all to know that there are sign-up sheets out in the hall right next to your registration for CLE credit to get involved with the Diversity and Inclusion Committee if you're so inclined. We meet monthly, and we are already planning a series of CLEs for next bar here. And also to let you know that the Seventh Circuit Bar Association's annual meeting is scheduled for April 29th through May 1st. The agenda for the program is on the Seventh Circuit Bar's website, which is thecircuitbar.org.
Thank you. Thanks so much for the opportunity to be here today. I'm really excited to hear from all of our speakers, so I'll keep my introduction brief. Again, I'm Ami Gandhi with Chicago Lawyers Committee for Civil Rights, and we're a nonprofit, nonpartisan organization. I know those of you who have been attending this series have heard about our work. And in addition to our voting rights project, which you'll hear about today, we also have opportunities for community work and pro bono service in other areas of civil rights, including housing opportunity, education equity, our settlement assistance program, police accountability, hate crime, community economic development, and the list goes on. So we hope that you stay involved with us even after today's program. We have been doing nonpartisan voter protection work for quite some time, Chicago Lawyers Committee for Civil Rights, as well as National Lawyers Committee and other affiliates. This has been during every major election, and even some elections that you might not think are so major, but that have a very important impact on the local level, and where a few votes really do make a difference between who wins and who loses and what the impact is on the community. And we realized that there was an area where we needed to deepen our voting rights work, especially because of the community input that we were hearing from communities of color, low-income communities, others who have been disenfranchised in the past and still, unfortunately, today as well. And so in recent months, we've started strengthening and deepening our work relating to voter access for community members in the criminal justice system. And it's, again, because of our civil rights focus, but also just because of the stories we were hearing from the community. So a lot of you know that we run a voter protection hotline with National Lawyers Committee and others, 866-RVOTE. And we received a call during the November 2016 election from a community member who had recently left incarceration, who, according to Illinois laws, was eligible for his voting rights to be restored. And He had secured a job and secured housing against the odds. He had a work ID. He was trying to go through the process of registering, and you can imagine that a work ID might have your photo but wouldn't have your home address on it, so that wasn't sufficient for him to use to register. And we're in a state in Illinois where we don't typically need ID when we're going to vote, but we do need ID to register and get on the rolls, and he was taken off of the rolls when he was serving a sentence for a felony conviction. So he's trying to get an ID to register to vote, and he tried to get a state ID. And in order to get that, he needed a social security card or a birth certificate, and he was not able to locate a social security card, and he tried to get his birth certificate from his home state of Minnesota, but the authorities there were saying that they needed a notarized application for him to be able to get his birth certificate, and the notary public would not notarize the application because he didn't have a state ID. And so the notary public wouldn't take him at his word, or didn't feel like she had sufficient documentation that he was who he said he was. So he was trying everything he could to follow our rules, but was not able to utilize Election Day registration that we're very fortunate to have in Illinois, or the other voter access programs we have to register and to vote that day. And we even had, between our volunteers in the field and well-intentioned election officials at the polling place, tried to get the parole officer on the phone to, again, attest that this voter was who he said he would, but there just wasn't sufficient documentation that could be used in that moment for that person to be able to vote, unfortunately. So we still have barriers like that we need to try to overcome in Illinois, and of course across the region and across the country. And we also realized from that situation that we needed to hear input and stories directly from community members who are in the reentry process or who are incarcerated or otherwise touched by the criminal justice system, because otherwise we may not structure programs and voting in a way that is really going to make a meaningful difference. So some of the things that we have started to do as a result are including, we participate in a think tank at Stateville Correctional Center. You'll hear more about that today from one of our speakers, because for far longer than we lawyers have been involved in thinking we have good ideas about voter access for community members in the criminal justice system, people who are directly affected have been formulating some really smart ideas about how to improve civic education, voter participation, other ways of being involved in our democracy. We also started working with local election authorities, correctional institutions, organizations like Chicago Votes, who's here today. If you want to raise your hand, this is a fantastic community organizer and leader from Chicago Votes, Shriver Center, ACLU, and other organizations represented here in the room today who have been working hard to improve voter access for individuals in pretrial detention. So that's another community that we're going to talk about today. Just as an example, in Cook County Jail, the vast majority of individuals in Cook County Jail are eligible to vote, over 90%, but have not had a practical way to exercise that right through most of our history, which advocates are trying to change through legislation, but that change has not come about yet. Last year, we participated in a pilot program during the suburban municipal elections. And last Saturday, along with Chicago Votes and others in this room, we were able to monitor voting at Cook County Jail, where hundreds of individuals were able to cast their ballot thanks to advocacy from community organizers and other champions at Chicago Votes. So there's some encouraging news on many fronts that I've talked about, but some all too familiar stories of these long-lasting barriers to voting and connection with racism as well. And to put that into context as far as where we are right now and where we should go from here, we have an incredible panel assembled today. So I'll share just briefly about our panelists before we get to the good part of the discussion. And you have more information about the fantastic biographies and achievements of our panelists in your materials you received for today's CLE. So first we have Nancy Abudu, Legal Director of ACLU of Florida. We also have Leah Aden, Senior Counsel of NAACP Legal Defense and Educational Fund. We also have Mr. Nasser Blackwell, community organizer at Inner City Muslim Action Network, also called Iman. And last but not least, we have Dr. Christina Rivers, an associate professor of political science at DePaul University and the coordinator of the Law and Politics think tank at Stateville Correctional Center. So let's give our panelists a welcome. So I want to start by asking our panel, and anyone should please feel free to chime in, but can you share some context, please, about how felony disenfranchisement laws came about in our country's history, and also share some basic background we should know about the status of these kinds of laws nationally and in the Seventh Circuit in particular, given that we have members here from across the Seventh Circuit, so that's Illinois, Indiana, and Wisconsin.
I'll jump in, but I'm going to certainly ask Dr. Rivers, Christina Rivers, to augment my response, and Nancy and Nasir as well. So my organization, the NAACP Legal Defense Fund, this is Thurgood Marshall's organization. For nearly 80 years, we've advocated on behalf of Black people. And this issue of felony disfranchisement, as Ami mentioned, is one of the more salient issues whenever we go out and talk to communities. This is the issue that they ask, what are you doing to address? Because, as was mentioned, 6 million people, more than 6 million people are now impacted by felony disfranchisement. And we didn't get here overnight. We have a history in this country of felony disfranchisement laws. And Dr. Rivers is going to take us back to how those laws are rooted in ancient Greece. They are rooted in our colonial American history. But for Black people, these laws came to be revised and to become more stringent, just as Black people after the Civil War were being brought into the political process through the enactment of the 14th and 15th Amendment. So as the Civil War is ending, as the 14th and 15th Amendment are enacted, and Black people are becoming part of the political process, legislatures in the Deep South, like Alabama, like Mississippi, like Louisiana, but not exclusively, this is occurring in New York, this is occurring in New Jersey. They're at the same time enacting felony disfranchisement laws alongside poll taxes, grandfather clauses, white primaries, all of the things that our Constitution and the Voting Rights Act of 1965 have now said are unconstitutional. Though the Voting Rights Act and the Constitution have yet to recognize that just as these race-neutral laws like poll taxes and grandfather clauses are intentionally discriminatory and certainly have a disparate impact on racial minorities, so too do felony disfranchisement laws. The history of those laws also didn't just end with their enactment in the late 1800s. You can link their intent and their impact to the interaction with today's criminal justice system. So the mass incarceration resulting from the war on drugs, from disparate sentencing around crack and cocaine, from the disparate rates at which people are arrested, all of that continues the history that became much more targeted and rigorous towards Black, Latino, and other communities of color following the Civil War. And this history is pretty clear to us at the Legal Defense Fund. So you have, after the Civil War in places like Mississippi or South Carolina, legislatures in the late 1890s revising their laws to disenfranchise people for felony convictions that they assume are going to be the ones that are most likely to be committed by Black people. So these are all based upon racial stereotypes. So in Mississippi, the laws were enacted so that you could be disenfranchised for burglary or theft, and this is true in South Carolina and other places. But if you embezzled or if you murdered someone, you would not be disenfranchised under those laws. And that was based upon the assumption that Black people are going to steal, they're going to commit petty thefts, but that they are not likely to embezzle or to murder people. These are the assumptions that undergird some of these laws. And those laws, while they have been modified and changed over the course of the time. From our perspective, the core of those laws is rooted in this racial discriminatory history, and the taint of the racial discrimination remains present in the laws that are on the books today, which now span 48 of the 50 states. The two places in our country where you can vote with a felony conviction are, no surprise, Maine and Vermont, which have a 95% white population. Everywhere else, and the data suggests that between the 1850s and in the early 2000s, all the states that have revised their laws, enacted new laws, those track the trend in those states to have more people of color, the geographic, the demography of those states changing and becoming more brown, more black, and so forth.
And
Yes.
so here's the question. That background was really helpful. Before we go way back and talk a little bit more about the history and the precedent for this, can you clarify, when you're talking about felony disenfranchisement laws, are you talking about when people cannot vote while incarcerated, or even after that, or, what's the scope of this?
So, our scope is the laws that are as stringent as Florida's and Kentucky's and Ohio's, where you cannot vote if you have a felony conviction for the rest of your life, absent some exceptions. To states like Illinois or Indiana, where you cannot vote while you're incarcerated, but you can re-register, and once you are on probation and parole, you can get your rights restored. You can re-register and vote again. To laws that, like in South Carolina, part of your service, you have to get out of jail, you have to complete probation and parole, and you have to pay all of the civil fines associated with having a felony conviction. We think that all of those laws are racially discriminatory, obviously have a disparate impact on communities of color, but there are variations. Every of the 48 states has a different variation on felony disfranchisement. But from our perspective, if it's okay for Maine and Vermont to allow people with felony convictions to vote and their state hasn't imploded, why isn't it the case that you can do that in Illinois, that you cannot do that, in Illinois, you cannot do that in New York, you cannot do that in California or Alabama or Kentucky or so forth?
Thank you.
So I'll take you back, but I won't keep you back there for very long. The principle behind, can everyone hear me? The principle behind felon disenfranchisement laws is referred to as the principle of civil death. And so based on the research that I've done, there are some historians that take that tradition back to the medieval era. There are other researchers that can trace it back to the Greek era, the ancient Greek era. And it really sort of reflects what later came to be known, affiliated with Rousseau's social contract theory, this notion that if one commits a crime against society, that one forfeits one's civil personhood while one is serving out whatever the penalty is for that particular crime that they committed. So this notion of civil death effectively kills the person off politically until they have paid their debt to society. That's where it came from. Now, of course, these laws at the time, this principle at the time didn't have the same kind of a racial animus or history, a racist animus or history then as they do now. But that's really the principle behind felon disenfranchisement. As Leah pointed out, this principle was sort of imported over with the colonists. So during the colonial era, you had some colonists that imposed the same type of limitation. You had others that didn't. It was inconsistent. And of course, you have these two outlier regions of Vermont and Maine. You know, they've always done things a little different. They're independent. And so they, to my knowledge, have never disenfranchised folks while they were serving their time. Vermont may have for a time, but they changed that practice and allowed those serving out a felony sentence of conviction to vote while they were serving their time. I think that changed around the 1860s. So this is a long tradition that they have in Vermont and Maine. So that civil death is the principle behind felon disenfranchisement. Pragmatically, Leah laid it out very well. What it ends up doing when you layer on all the sort of racial and anti-immigrationist intents is that felon disenfranchisement laws, particularly in the South, in the process of felonizing what were at the time misdemeanors, petty theft, vagrancy. Not, of course, a lot of people in the South during the Reconstruction era and after Jim Crow didn't have jobs, right? So vagrancy was felonized. What ended up happening is blackness, if you will, was felonized in the South. And people who were new to this country, stereotypical behaviors of people who were new to this country, their very essence in that respect was felonized. So again, you had laws that targeted behavior that was perceived to be things that only Black people would do. Those were the laws to which these disenfranchisement laws were attached. Those were the crimes, to which these disenfranchisement laws were attached. And so felon disenfranchisement laws absolutely have a racist history. They have an anti-immigrationist history. And even though some of those laws have been changed, the animus behind those laws, in my view, has not been purged. It has not been addressed, it has not been purged, and in my mind, it's still there. So just to throw a few quick numbers at you, and I'm not a numbers person, but ironically today I'll be throwing some numbers out. In the opening comments, it was pointed out correctly that about 6.1 million people right now are under penal supervision and therefore cannot vote. Again, Florida, Kentucky, Alabama partially, and Iowa have permanent disenfranchisement laws, and I can't wait to hear Nancy talk more about what's the exciting things that have been going on with Florida with respect to that. Overall, 7.4% of the adult African-American population in the US is disenfranchised because of a felony conviction. That compares to 2% of non-African Americans in this country. In the states that I just mentioned, Florida, Kentucky, Tennessee, Virginia, anywhere from 20 to 25% of the Black population is disenfranchised in those states. So the profound disproportionality of these laws is inevitable. It's inescapable. And so, again, there's been some exciting movement to change what's going on, but that's sort of the principles of what's behind these particular laws.
And it would be great to take it from there and talk about, I know a lot of lawyers in the room and probably everyone in the room is wondering how we can challenge those laws and what's being done on that front, including the groundbreaking work by some of your very organizations. So can you please share, whether it's through litigation or other strategies, how communities in different parts of the country are going about trying to address these laws?
Well, first, thank you for having me here. It's definitely an honor to be on this panel with colleagues with whom, such as Lee, I've worked with. And just to, definitely want to answer your question, but just to piggyback on the excellent summary that was given, number one, as Professor Rivers stated, even though you had a number of states like Alabama and Florida that were found to have enacted their original felon disfranchisement for, racially motivated with racial animus, the reenactment of those laws, as Professor stated, has not eliminated the ultimate result. With Florida in particular, 21% of our African American population remains disfranchised because of our current felon disfranchisement law. And then also want to say, going in the area of legal challenges, one of the things that the ACLU tried to challenge was the application of Section 2 of the 14th Amendment, which is the provision that the Supreme Court relied on to say that states do enjoy discretion when it comes to deciding whether or not to deny someone the right to vote based on a criminal or felony conviction. And so we argued in an Arizona case that even if we accept that proposition, that at the time that Section 2 was enacted, we didn't have the plethora of laws or crimes that we have today. And the key phrase in Section 2 is actually felonies at common law. And so we really tried to narrow the scope of that so it couldn't include all of the vagrancy and other misdemeanor crimes that many states, including Florida, have elevated to be felonies. For example, even when you think about theft, I think about $300 theft of an object that has a value of $300 is a felony conviction that could result in prison time and, of course, the loss of your civil rights, including the right to vote. Other areas or strategies that we've tried to advance include just due process. I know we're going to hopefully talk a little bit about the right of pretrial detainees who have not lost their right to vote, but we've tried to argue that because of the confusion in the restoration process and the lack of education coming from public officials and especially election officials to the general population, but specifically those who do have criminal convictions, a lot of folks don't know what their rights are and don't know how to access those rights. And Alabama is an example where they have a moral turpitude standard, and yet at the time, didn't have an exhaustive list of which crimes constitute moral turpitude. So we had a situation of our clients where you could be convicted of the same crime, but depending where in the state you live, the clerk of court might go ahead and restore your rights. And if you were in another part of the state, that was not the case for you. And so we tried to really argue that this system was too arbitrary. The lack of education resulted in some serious due process violations. Equal protection, of course, and trying to draw upon Section 2 of the Voting Rights Act, which prohibits the enactment or enforcement of voting practices that result in the denial of someone's right to vote based on their race or national origin or being a member of a language minority. And we tried to show that when you couple the racial bias in the criminal justice system with felon disfranchisement laws, it's no surprise that racial minorities are the groups that are most impacted by this, resulting, we argued, in a violation of the Equal Protection Clause. And unfortunately, I think overall the legal landscape when it comes to felon disfranchisement has not been as successful. So those are just a couple of the theories that we've put out there. Free speech, we got a great decision recently out of a Northern District judge in Florida, really relying on the First Amendment for his conclusion that the arbitrary way in which Florida's clemency process operated resulted in a violation of the client's political rights. And so we've been trying to rest a little bit on the First Amendment there too. So, and we're open, I hope, during the discussion period to other avenues to challenge these practices.
Before, I want to talk with Nasser and others about pretrial detention, one of the topics you mentioned, Nancy. But before we turn to that, Leah, did you want to jump in with anything for a quick minute or two about other strategies in addition to litigation to try to address these laws?
Yes, with just adding one quick thing with onto Nancy's reference to the Voting Rights Act. So I'm glad that you guys learned about Section 2 in another session. This is the provision of the Voting Rights Act that's affirmative. You can go into court and try to uproot a law. And unfortunately, in an uproot a law that has either the purpose or the effect of discriminating, denying, or abridging the right to vote. And New York, unfortunately, determined that Section 2, Congress did not intend Section 2 to apply to felony disfranchisement laws. Section 2 has been used to challenge photo ID laws, changes to polling places, redistricting, but it doesn't, according to the Second Circuit precedent, it doesn't apply to felony disfranchisement. Then you get across the country to a place like Washington State where we use Section 2 to try to challenge felony disfranchisement laws, and there the Ninth Circuit says, yes, you can use Section 2 to uproot felony disfranchisement law. You can use the Voting Rights Act to uproot felony disfranchisement laws, but we're going to create a standard that is nearly impossible for you to meet so that you actually cannot use that provision to uproot them. And essentially, even though Congress recognized in 1965 that you do not have to show purpose behind laws to strike them down. You can show their disparate impact. The Ninth Circuit has now said that in order to challenge felony disfranchisement, you have to prove that the law was intentionally discriminatory, enacted, that legislators as a whole enacted the law with a discriminatory intent, or you have to prove intentional discrimination in every aspect of the criminal justice system that interacts with the felony law to deny people the right to vote. So that's intentional discrimination in the arrest process, in the charging process, and the sentencing process, which is, for those who have brought intentional discrimination claims, nearly impossible to do, and therefore foreclose that. So even still, there are warriors for justice who are bringing these claims under the Voting Rights Act in other circuits. raising First Amendment claims, really trying everything, because the goal of the litigation is to strike down the whole law, because we think the whole law is tainted at its core, is sick at its core. In the interim, when we can't when we have not yet established a precedent for doing that, there has been federal legislation that's been enacted, the Democracy Restoration Act, that we and many other groups like the ACLU and Brennan and others have supported, which would basically eviscerate those felony disfranchisement laws at the federal level. So you could vote in federal elections having a felony conviction. Of course, regardless of the administration that's been in office, that law has gone nowhere. And so then we go to the states and we try to chip away at the outer core of these laws. So in Louisiana, there is litigation under the state law now. It's really a question of statutory interpretation. People who are under order of imprisonment in Louisiana, which has one of the highest incarceration rates in the world, cannot vote. And so what does order of imprisonment mean? We think when you're in prison, when you're either in prison or you've escaped prison, you cannot, that's felony disfranchisement reaches you. But if you are on probation and parole in your communities, you're not under order of imprisonment, at least looking at the legislative history. And so folks are trying to chip away at the law so that courts will interpret that this Louisiana Constitution to allow people on probation and parole who are not under order of imprisonment technically to vote. And that has been the case in places like California or Maryland, where the laws have been chipped away at the core of felony disfranchisement exist in those places. But if you're on probation and parole, if you are under mandatory community supervision or otherwise, those states have enacted laws so that you can re-register, go through the administrative hurdles of having to re-register, but you can re-register and hopefully get your right to vote. And so that's separate and apart from striking down the laws in whole. That the next phase has been trying to either get federal legislation to address it or chip away at the edges of these laws to get more people involved in the political process rather than whole segments of populations completely excluded for large periods of time.
Thank you. Yeah, I just
Yeah,
wanted
I just
to.
want to state,
Yeah,
one
please
of
go
the
ahead.
most effective ways in addressing this, outside of the policy work, because this is difficulty we have, and even though we have policies in place, it's the knowledge. It's those who are affected, directly affected. They have no idea they have the rights to vote, or many of their rights restored. Just this very morning, I was talking with one of the cohorts in our Green Ranger program, just recently returned home from prison. He had no idea his rights were restored immediately in the state of Illinois. It wasn't until I shared the flyer to the Chicago Lawyers Committee Civil Rights shared with our groups that I'm educating these individuals that not only are your rights restored,
This flyer, if anyone needs
right,
it.
not only are your rights restored, but do you know where to vote at? You know, have you registered? And thankfully, our Secretary of State and Illinois Department of Corrections championed a piece of legislation where returning citizens receive their state IDs upon release. That process is done for them, assisting them obtain these documentations such as birth certificates, such as social security cards, so they can restore their rights immediately to vote and they can go register. The problem with that is it takes a week to 2 weeks to receive that state ID. So these individuals is walking around with a paper ID, which many agencies determine as invalid. Even though it has a place of residency on there, they feel as if because it wasn't identified as a place that verified that place of residency, other than someone that photocopied it, and I understand both sides of the argument, it could be forged, but they're still having a problem through that process. And where do we go when we have an election period and people coming home from prison waiting these IDs? So we definitely need to address that. And the education part, the mobilization, ground roots organizing. You know, Iman, we have what is called Grassroots Power Hour, where we address real issues within our communities every Tuesday night. Just last night, we had a long discussion about voter disenfranchisement, educating our community members, as well as other returning citizens that live in the community that's totally unaware of it, and just giving them a brief history of how history continued to replace itself. How did these disenfranchisement laws come into place? How did these policies come into place? And it's just practice of those who empower, who feel threatened by either a class or another group of individuals. And they are fearful of losing that reign of power. There's, what's the word I'm gonna use? I'm trying to, there's a reality to the fact that people of color pretty much dominates the country now. But through census, we can isolate that. Blacks, Hispanic, Latinos, Asians, Puerto Ricans. We can separate each particular group and alienate one against the other consistently through census, through gerrymandering. And this is a big problem that we're having, especially in southern state of Illinois, where Michelle from the Strawberry Center articulately stated, like Pinckneyville is an excellent example. They wouldn't even meet the population requirement if it wasn't for the prison in that area. But yet those individuals in the prisons are predominantly from the Cook County area, because the Cook County area represent over 55% of the releases from prison every single year. But those resources and their representation from Chicago and the Cook County area in the northern area of Illinois is now directed to the southern states.
So let me ask you this, and I want to request Margot if someone could help me with unlocking the computer, which I tried and failed, because I would like to show a video precisely about prison-based gerrymandering and the great topic that you brought up. But while we're working on the tech issues, can you break down a little bit more about the lack of awareness that you mentioned that some of our communities have? Because when I first got to meet you and hear your story, and several people in the room here were there as well, when you testified before the U.S. Commission on Civil Rights at their hearing last year about voting rights in Illinois. And when you talked very specifically about thank you, Margot, about the information that you received in jail as well as after incarceration in prison, I think it helped to explain for a lot of people and bring to life that it's not just like our community members are trying to be ignorant of rights, but there are so many dynamics and practical circumstances that come into play that make it really, really incredibly hard for someone to know the process to exercise our voting rights. So if you could talk a little bit more about that, your own experiences, that would be helpful.
I think that's an excellent question and an excellent point, because the ignorance lies not just with those who faced incarceration, but those who enforce the institution of incarceration. Because many staff members in the county jail feel as if because you was unable to post bail in your pending trial, as a result of your detention, you lost your right to vote. And I was confined in the Will County Jail in the 1990s and demanding the opportunity to participate in the electoral ballot process, and I was told to shut up and go lock up. It's so many nice words. And I was told that I lost my right to vote because I was contained in this county jail. Well, this exists in many southern areas of Illinois, that jail officials really do not have the full knowledge of what the laws consist of, especially Illinois laws, in regards to those that are detained. And so the education is critical in informing everyone of their rights, but more importantly, enforcing that rights upon those institutions that detain these individuals.
Thank you.
Can I add to that? Do you want me to do the breakdowns?
Please, go ahead.
So related to that, I have been supervising a law and politics think tank at Stateville Correctional Center for about 1.5 years, and this was an outgrowth of a class that I taught there, sort of a survey law and politics course that I taught there in spring of 2016. And so like any good professor, I made them read my own work. And this was when I was just starting to investigate myself these issues of felon disenfranchisement laws and prison-based gerrymanders. And
Any slides of yours you'd like me to
I
bring
did
up?
include.
Would you like me to pull it up?
Yeah. And so what we got to talking about was how much confusion that those on the inside had about their voting rights, and even those on the outside in terms of their family members had. And so anecdotally, I remember mentioning to one of them, you should do a survey. He was saying he's starting to have these conversations in the chow lines with others of his colleagues as they were waiting around or out on the yard. And so I was like, yeah, you got to do a survey. And so with this think tank, they did. And so they surveyed themselves. They wrote the survey themselves. The only thing I did was type it up, print it up, and bring it back. And we passed out, is this the slide? Yeah, we passed out about 275 surveys, and we got back about 103, which is a great response. And the results completely fly in the face of standard conventional thinking, particularly in my discipline of political science, where we're way behind in joining this party. The prevailing political scientists, if you read anything that we write on this, would suggest that those who have a felony conviction, whether they're serving the time for it or have served it out, are really sort of apolitical or apathetic. And that's just not true. And so if you look at these numbers, 64% of those who took this survey had already voted. And we kept that question open. I said in any election, so this could have been a high school election. I had them sort of fill in. Some people had voted in their unions, but 64% had voted prior to incarceration, some of whom had voted while detained in jail. And I know several folks with whom I work at Stateville, the first time they voted actually was while they were detained in jail. So that completely flies in the face of standard thinking about disengagement amongst this population. 98% said they'd vote while incarcerated. You can see the answers here. 93% said either they very or somewhat closely followed the 2016 campaign. Now, the 2016 campaign was unusual in its degree of inability to turn away from it. But that's a very outstanding number of people. I think it's actually more than the students that I teach of this population that follow the election. So the gist of these numbers is that you have this very low knowledge of how to gain their political rights, their voting rights. So while 64% said they'd voted prior to incarceration, only 37% knew how to regain their voting rights. Knew that they had those rights when they get out, and only 22% knew how to get those rights. So you have a very high level of engagement, a very high level of political interest, high level of political knowledge, but a very low level of how to exercise those rights. And so it really speaks to this notion of the importance of education. And so many of the people with whom I work have told me stories about wanting to exercise their rights while they were detained and being told by the sheriffs or their corrections officers, no, you are ineligible to vote while you're awaiting trial. And it's unclear whether these staffers were themselves genuinely misinformed or if this is just the power that they had to prevent this from happening. I mean, that's tough to guess, right? But that's a problem as well when you have staff that should know better that don't. And so for those who want to and are able to exercise their voting rights are being told incorrectly that they cannot. So there's another group of organizations that did a similar survey and came up with similar responses, not as high into the extremes as this particular survey. But I think what's really the most important takeaway is this very high level of interest. And this is on the part, by the way, of people in an institution, most of whom are not getting out. And so if you have that level of engagement on the part of a population who's not getting out, and it's very unlikely that they'll be able to vote, one can only extrapolate what this would mean or how this would pan out if this survey were done in a medium security place, for example, where folks were going to get out in a couple of years. So there's this high level of engagement and interest, low level of knowledge, where the answer is education through other processes, both while people are serving their sentence and when they get out.
So let's change the order. I was actually thinking, we can come back to prison-based gerrymandering in a few minutes, but I really would like to hear, maybe we're on the same wavelength, but I would like to hear more about Florida in this conversation about voting rights restoration before we change topics. So if you can please share, if that's what you were going to mention, or chime in with anything else as well.
I wanted to emphasize or further support what was said in terms of it's not just about a lack of education on the part of impacted persons, but also for sure election officials. And we actually sued the state of South Dakota on behalf of 2 women from the Pine Ridge Reservation who were serving probation. And so one of our clients actually, this was during the 2008 election, went to the polling place with her son, knew that she had the right to vote under South Dakota law. And it was the poll worker who not only told her that she could not vote a regular ballot, but refused to give her a provisional ballot. And everyone, even if there's a question on election day regarding your eligibility, you have a right to cast a provisional ballot, and then it's decided later or not whether it should count. We ultimately won that case, but I'm learning more that it's what we call at the ACLU, at least an integrated advocacy approach is absolutely necessary, because while we won the litigation, South Dakota just turned around during its legislative session to deny provide voting rights to people serving probation as well. So even though we won the battle, we ultimately lost the war, and now we have to go back to, you know, the starting point, but now the landscape is even worse for us. And so that's just to show that it really does take more than litigation. Litigation is not the answer, the only answer to this issue. But yes, Florida gives us some hope. We're one of the 4 states that was mentioned earlier that we consider to be a permanent ban on the right to vote. Not only do you have to completely satisfy all of the conditions of your sentence, including oftentimes very high monetary amounts related to fines, fees, and victim restitution, but through our governor, Rick Scott, who imposed upon getting into office a waiting period, 5 to 7 year waiting period before you could even apply for restoration of your rights, and then the time to even find out whether or not your application was being reviewed, not whether or not you should show up for the hearing, not whether or not it's being decided, but it's just being reviewed, has taken years and resulted in thousands of people in the queue in terms of getting their clemency applications even seriously considered. I also note that because our previous governor, Charlie Crist, through executive order, amended the process to make it pretty much automatic. So if you had satisfied certain conditions, then you had done enough for him to automatically grant you clemency. And during his administration, there were about 150,000 people who got their rights restored. Now you have to compare that to under our Governor Chris, whose term ends, he's term limited out in November, about 2,300 people. So you can see a huge difference in terms of what the power of a governor when it comes to addressing this issue. But we were successful in getting over 1 million signatures in support of a ballot initiative that would automatically restore voting rights for almost everyone after completion of sentence. The carve-out and the compromise was for those convicted of murder or felony sexual offenses, and that decision involved a lot of integrated advocacy and conversations with community members and polling to just, you know, I mean, we're in a tough state in Florida, so we're trying to win. So what is the message that's going to resonate most with the community to allow us to get over this hurdle? So we needed 766,000. We got over 1 million. It's going to be on the ballot in November. We need 60% for it to pass. So again, we're feeling very confident. And in part, we're feeling confident because we've been able to push back on efforts to make any kind of improvement not as significant as what the petition is advancing. For example, we have a Constitution Revision Commission. We might be one of the very few states in the country that actually allows a body, mostly appointed by our governor, to decide which changes are necessary for our Constitution. And so the issue of felon disfranchisement was one that the Constitution Revision Commission seriously considered, but we knew that anything coming out of this commission would be worse than what we wanted on the ballot, so we were able to push back against that. We're able to push back against any legislative fix. We've tried for years to have the legislature address this issue, and now that we were actually gaining the momentum and were able to get it on the ballot, all of a sudden they wanted to try to think up, again, a bill that would be more restrictive. Our session thankfully ended on Friday, so we were successful in pushing back against that. It's really been citizen, community-led, impacted persons. Desmond Meade, who's the president of the Florida Rights Restoration Committee, it's his story and the story of others that's really helped to put a face and humanize the issue for so many folks. I think that, if you are just thinking of criminals, felons, there's no connection. But in reality, with the numbers that we're looking at, almost everyone probably in this room knows someone or knows someone who knows someone, if not yourself, have had to deal with some interaction with the criminal justice system, which might have resulted in a conviction and therefore resulted in a loss or a threat to your right to vote. So that's kind of the work that we're doing. Again, we're doing a lot of polling to see which messages messages work. We know that unfortunately, race it doesn't work. People are not, we live in, and this is my opinion, that Florida is not as advanced when it comes to racial justice issues. And so when we're looking at still pretty much a majority white population, they're not interested in the voting rights of racial minorities. But when they can imagine themselves or their son or other family members, it makes a difference, and part of the reason why we were successful in getting so many signatures. So even though race is definitely a part of why this law exists, there are questions that we're deciding whether or not that's how we want to lead. We're identifying veterans who have served, done the highest service to our country, who come back, face various problems, and end up in the criminal justice system. So our website is profiling the stories of those veterans, and we're leading not with, restore the vote to people with criminal convictions, but we're leading with second chances, that everybody has benefited from a second chance, and this is just another form of that, which is part of the rehabilitation process, if indeed our system, our criminal justice system, is supposed to be about that.
So my last couple of questions before we have some time for questions from the audience are getting at, what about people who are eligible to vote but not interested? And this is the primary season here in Illinois. We have our election coming up in a few days. And so a lot of our local and state conversation is about that across various segments of our community. And as Nasser mentioned, one of the reasons that some people who are otherwise civically engaged may have some frustrations around our voting process is because of what they see as more systemic barriers to their vote counting or making a difference. And so I wanted to, if the technology cooperates, show a short video about prison-based gerrymandering, an important topic that you mentioned earlier, and hear if our panelists have insights into that.
We're in Anamosa, Iowa, where a man got 2 votes and won a city council seat. He wasn't a candidate, he didn't vote for himself. He went to work one day, and his wife and his neighbor voted him into office.
Well, the mayor called me first, just asked me if I would be willing, that I had 2 votes.
The census counted about 5,500 people here in Anamosa, so that means about 1,374 people per district. In that election, nobody was on the ballot as a candidate. 3 write-in votes were cast, but 1 was for a candidate who didn't live in the district. The other 2 votes went to Danny Young.
I said, well, I'd give it a try.
Problem in this election wasn't voter apathy. It was a lack of voters. The district includes Anamosa State Penitentiary. Prisoners can't vote, but the U.S. Census counts them where they're locked up. There were 1,321 prisoners counted here, so 96% of this district wasn't allowed to vote. Each of the city's other council districts had 25 times as many real residents as this one. So in effect, if you live next to this prison, you had 25 times as much influence.
Having one person represent 58 people and another person represent 1,500, 1,300, you're not getting equal representation.
Also, it means a very limited pool of potential candidates to serve on our city council.
If you're a legislator, you want a prison in your district. Perfect district from the perspective of an elected official would be your house and a large prison, because as long as your spouse is willing to vote for you, you're guaranteed re-election. The question of prison-based gerrymandering is a new question. Some people didn't notice that prisoners are counted in the census, or they didn't question what could be done about the problem. There's 7 New York State Senate districts that would not meet minimum population requirements without using the prisoners as padding. Districts are supposed to be based on population, but when prison populations are used to pad certain legislative districts at the expense of everybody else, we have a situation of representation without population. If the Census Bureau counted people in prison at home, this problem would be over.
Please go ahead.
So I'll jump in and provide a little bit more context, and then definitely want to hear from others about their advocacy around this issue. It's not talked about enough, but it is a big issue, and it's one that we should all be aware of, because there's going to be another decennial census occurring in 2020, and many of you have been following the census. It's been underfunded. We're worried that there's not enough money to conduct the census. There's not a director of the census right now. He stepped down because he was concerned that the next census was not going to be be conducted in a way that fulfills the mission of the Census Bureau. And there is a fear that the census might also not be accurate because there's been a drive to put a citizenship question on the census so that people may not participate because they don't want to ask questions about citizenship in this climate. But the census is going to happen one way or the other. The question is, how accurate is it going to be or not? And one of the questions is, where do you count people who are incarcerated on census day? Do you count them in their prison facilities, or do you try to get the data to figure out where they lived pre-arrest in their home communities? And this matters because when the census data is released, what flows from the census data is billions of dollars in funding to states and local jurisdictions, and it's the data that is used not just at the congressional level, but at the state level and for every city council, school board, water district, judgeship, electoral district that's drawn during the redistricting process. When people who are imprisoned are counted in prison facilities, given where prison facilities are located, the areas that are often rural and overwhelmingly white get the benefit of imprisoned populations, even though, as we've talked about, many people who are imprisoned cannot vote. They cannot use the parks in those communities. Their representatives may not even see them as constituents because they can't vote for them. And inversely, the people who lose out are the communities where they come from. The census count has impact for 10 years until the next census. And so even if you're incarcerated for a year and you're counted in your prison facility, when you go home, the redistricting lines have already been drawn, even though you're going to spend 9 years in your home community. So many of the groups up here have been advocating for the census to treat incarcerated people just like they treat boarding school students or people who are away, like in the military on census day when they're deployed out of their community, to treat them in their home communities. And if the census did that, then the burden wouldn't be on states to change the data once they get it during the redistricting process to count people in the right place. And in fact, it would make it easier. There are 4 states, California, Maryland, Delaware, New York, that have recognized this problem of prison-based gerrymandering, counting people in the wrong place for redistricting, and have required that people be counted in their home communities when you are drawing district lines. And there are around 200 plus local jurisdictions that have gone about doing this on their own. But for the most part, Illinois, Rhode Island, Connecticut, these are all places that have contemplated going in the direction of Maryland and New York and California, but legislation along that lines has not been successful. LDF has been advocating since before the 2010 census for the Census Bureau to count people more accurately in their home communities. They didn't do it in 2010, and we just learned that they're not going to do it again for the 2020 census. They lack the political will to make that change. And so we are going to continue to have to do what we've been doing, which is to encourage state legislatures to come up with bills like California, New York, and Delaware, to require that people be counted in their home communities for the redistricting purposes. But the outcome, this process benefits mostly rural white communities, and the inversely works to the detriment of urban communities of color. And so it's another issue that has a racial impact, but disproportionately, but not exclusively.
Can I add to that with respect to what's going on with Illinois? So again, Illinois does engage in this practice. Pinckneyville, as you mentioned, is a particularly egregious example of that. It is really up to the localities to decide whether they want to count incarcerated people, and so some localities do and some don't. But Illinois definitely engages in prison gerrymanders. Representative LaShawn Ford has introduced legislation 3 or 4 times, I think, called the No Representation Without Population Act. There are some other states that sort of use that same name because that's exactly what this is. And each time, not surprisingly, it sort of dies, in committee, because that's where what happens to most legislation. And so the cynic in me is not surprised, but I'm also very disappointed that that's what happens. I've spoken with him about this, and I've spoken with a few legislators downstate about this, and the sticking point is funding. And the jury is sort of out on the funding effect on this. Dan Wagner, who is sort of this one-man wrecking crew to abolish prison gerrymanders, and I think that was him that was holding the flashcards there. I've spoken with him as well, and he argues that there really is no funding effect at the federal level, but I know of other colleagues who have proven that there is a funding disproportionality at the state level. It really depends on whether funding is attached to a person's head. And so what LaShawn Ford has told me, and other representatives downstate have told me, is that there are many who agree that this is an unfair practice, particularly, and Nancy, the deposition that you sent me on that Florida case was so illuminating. The people that represent these districts do not see prisoners as their constituents. They do not see them as their constituents. In fact, such constituents are referred to by those who write about this as phantom constituents, ghost constituents. So there's it's an extension of this notion of civil death. In my mind, they're almost like packing peanuts, right? They fill the box, but they're not counted. And so the big sticking point, at least in Illinois, has been, and one representative told me this, he's like, yeah, I think this is totally unfair. I think you're absolutely right that this practice should stop, but we want to keep the funding. And so there's this notion of sort of wanting to have it both ways. And so there's three options. You either count the person where they're incarcerated, you count the person at their last home address, or you simply don't count them at all. Mm-hmm. But the big sticking point in some of these areas has been they don't, even though there's a recognition that this is an unfair, disproportionate type of representation, there's a need by many of these communities, which are very impoverished communities themselves, for that funding, any funding that comes attached to these people who are behind those bars. And that tends to be the sticking point.
I did hear a complaint from a legislator, one such legislator before, about the water costs for incarcerated community members in the district, and not really any other connection to them than complaining about that.
And of course, a lot of the other benefits that accrue to these districts are not enjoyed by those people who are incarcerated. And water is really interesting. Those of us who go into Stateville, if we forget water, we're allowed to bring in an unsealed bottle of water. But several times I have gone to the water fountain and somebody just beats me to it and puts a bottle of water in my hand. They don't want us to drink that water. That water there is bad. And so even what's there is not sufficient. And, we could have a whole nother session on environmental issues that are related to prison communities. And so whatever public services are delivered to prisons, those services themselves tend to be substandard. So that's kind of a straw man type issue. But I just wanted to add that this is where we are in Illinois. I think Representative Ford reintroduced the bill in December of 2017, and it's still alive, but I'm not sure how far it's gotten between December and now.
So as a last question before we take questions from the audience, I'm thinking about Iman's work, I'm thinking about other work in community engagement that you all do, and when voting rates are still low, even in so-called voting rights restoration states, for these different reasons we discussed, but what input are we getting from incarcerated and reentering community members about how we can improve civic engagement and voter participation and democratic participation more generally? Can you share insights on that, please?
Yeah. What Iman has been doing is voter registration and education. Again, we use our Grassroots Power Hour, a program we developed that we can launch every week, probably through November, I believe. We normally launch a program every year. On every Tuesday evening, and it's just all about education. It's engaging our communities and informing them of their rights. It's engaging with the returning citizens. Language is everything. I mean, it's how we frame the language. We said returning citizens because they never lost their citizenship. We want them to feel empowered that you still have a right, you still have a voice. We have to get we have to get to the basic fundamental process, the basic fundamental principles of civic engagement. What is the philosophy of humanity? What is the philosophy of your human rights, your basic human rights? So without going in a whole dissertation in regards with this groups of individuals of philosophy, logic, and how we think and use our critical thinking abilities, I remind them when they was incarcerated with me, because I served over 2.5 decades, and a lot of them remember me because I was that law clerk. And one thing I always reminded them on when they come to me with their issues, and this has a lot to do with our representation. I knew about the gerrymandering while I was inside, but I intentionally challenged that state representative or that state senator in that district where that prison is based on prison conditions or particular individual's condition. And I challenged them to come investigate. 90% of the time they would not. It wasn't until I contacted this individual state representative where they came from, their county where they came from, when that matter was actually addressed. So it'd be individuals outside the district of the prisons up north in northern Illinois that's calling the prison saying, what's going on with this individual? Not the local representatives. They rarely, if any, represent the interests of those being confined in them cities, in them towns. And so this is the biggest part, is just continuing on with this civic engagement education. It's, again, 101 grassroots organizing. You got to put your boots on the ground to go out there and talk to everybody in the neighborhood. Is the community aware that the resources are left because their loved ones incarcerated in another county? No, they're not. They had no idea this was. And then what do you mean by loss of resources? So you have to educate them of that. When you start losing money in regards to funding to your schools, to resources in regards to mental disabilities, healthcare, most of your social services are redirected after our census. And a lot of people is unaware of that. And we have to educate the community around it.
Thank you. I think that's a great time to turn it over and hear from all of you. We have a little bit of time for questions for our wonderful speakers here. And then at 4:30, we'll conclude this part of the program and move over just slightly this way to a reception that we have where we'll have plenty more time to talk and pick your brains. And so we'd love to start with the first question from the attendees. Please, Julie, go ahead.
I have two questions. One's kind of at a super macro level and one's more micro. But the macro level is, Dr. Rivers, I was interested in what you were saying about the civil death notion. And I was wondering if there are examples of other democratic nations that have sort of a universal suffrage no matter what, whether it's incarceration or not. And you know, sort of historically how that has played out. And then my micro question is, on the automatic voter registration that's recently passed in Illinois, is there any possibility of linking that, like, to the Illinois Department of Corrections for release and mandating that people get registered upon release?
Yeah, I'm happy to answer that
take
one.
that one
Oh,
first?
sure. And the wonderful, talented reporter sitting next to you and I have talked about that same question before too. I think it's on a lot of people's minds because we supposedly have a lot of great voter access programs in Illinois, but getting it to be implemented is sometimes another story. So there is definitely that potential for Illinois Department of Corrections and other corrections-related agencies to voluntarily be involved in programs like automatic voter registration, but voluntarily is the key word in that sentence. It doesn't, with the way our state computer systems are set up right now, it doesn't lend itself to the easiest thing to do when in the agency system they would have many people who are ineligible to vote under our current laws because of currently serving a sentence related to a felony conviction. And then some people who have been released or discharged and then they are eligible. So it's more complicated, but just because something's complicated doesn't mean we can't find a technological fix. And so we think that it's important to keep that conversation going, even though the way the statute was enacted, it doesn't require anything automatic to happen for this group of future voters. And I think something I would ask us all to think about is that when we hear about youth engagement initiatives in voting or the idea of pre-registration or other ways that we value our young community members and look at them as future voters and future participants in our democracy and our society. We heard a comment from our Stateville colleagues a couple weeks ago about what about other people who will be eligible to vote in the future who are not looked at as future voters, such as incarcerated individuals? And do we as a society want to push for access and fairness there as well? So it's something we definitely need to ask ourselves.
And the short answer to your question, I don't have the data right in front of me, but I can easily say that the U.S. stands out not only in terms of our rates of incarceration. We have 5% of the world's prison, 25% of the world's prison population, 5% of the world's population and 25% of the world's prison population. There is no other peer advanced democracy that disenfranchises those serving out a prison sentence the way we do. Many countries, and even what would be sort of considered developing democracies, do not disenfranchise their citizens while they're serving out their sentence. So the U.S. is a real standout in that respect.
And I'd like to briefly comment. I was just reading some research information this morning. I do know an EU court just recently came down striking the French national right to vote because of his felony conviction. The court ruled that yes, a felony conviction can be used as a form of disenfranchisement.
Oh, really?
To stop this individual from participating.
So that's new. That's new.
Yeah. So that's just I believe that was last year or the year before, 2016, 2017, when that ruling came out from the EU, striking that French national right to vote or participate in the electoral process.
It's still unusual. I mean, again, I don't have the data right in front of me, but for the most part, most other advanced democracies do not disenfranchise people while they're serving out their sentences.
I would direct you to the Sentencing Project, has done a lot of the data and scholarship on this issue, and they do also try to do a lot of comparative analyses between our system and other systems. So the Sentencing Project, Mark Maurer is the director. And one other thing related to your first question, for lawyers who want to address also this issue of, in addition to striking down these laws, what to do once people become eligible to vote and getting them re-registered again and attacking those hurdles. In addition to linking it to the AVR, there's the National Voter Registration Act, the Motor Voter Law, a federal law that requires DMVs, public assistance agencies, and others to give people the opportunity to vote. And there's a real question about whether or not the National Voter Registration Act, the Motor Voter Law, extends to departments of corrections and other facilities. Do they, as a agency, have an obligation to provide registration information about how to register and opportunities to register when people interact with the Department of Corrections, particularly on their way out when they are eligible to vote? And there are people thinking about and working on that issue, but for people who are advocates, I would say that that's something that should be explored because of it's one of the last points of entry before people enter their community. Of the Department of Corrections is where they're getting their information about what they are eligible and not eligible to do. And it would be an opportunity, a place where people could learn about re-registration and get the opportunity to re-register, perhaps under a federal requirement.
I never thought about it that way. I'm glad you mentioned that about NVRA. Please go ahead.
And I was just going to add, there's research being done now, but the preliminary data does suggest that those who get their rights restored are voting at higher rates statistically than the general population. And Virginia was the last test case where they have a very progressive governor who tried to do a legislative fix to the issue. Yes, exactly. And then because the legislature decided for various reasons that he had to go through the clemency process, he was signing about 1,000 restoration applications a day. And those individuals who got their rights restored, by and large, did go ahead and vote in that next upcoming election. And I think when you compare that to the general population, where our turnout, I think it's pretty embarrassing, especially even in the 2016 election, as polarizing and exciting, some would say, as it was. Still the turnout was not great, or what I would think it should have been.
Just to add to that, and again, I'm a cynical political scientist here, but I face some of the same challenges with my students. And now, if they're volunteering to take a poli-sci class, they're probably somewhat interested in politics. But one of the lowest voting rates is amongst young people. And as they get older, that data has been consistent for decades. And so in that sense, to the extent that there's the perception, and I think it's more perception than anything at this point, that those with a felony conviction are disinterested and apathetic. First off, I don't think that's entirely true, but even if it is, it just sort of tracks a whole lot of the general population anyway. You're right, the U.S. does not have admirable turnout rates by any stretch of the imagination. But I want to say that in all the years that I've studied sort of voting rights and who votes and who doesn't, this is the first, I'm not aware of any other period where you have had recently such energetic movement toward restoring the rights of people with a felony conviction. And in particular, typically groups who are perceived to need assistance like that, this activism is done on behalf of one group of people for another group of people. This has been very led by those people who are the most directly affected. And again, I don't have any recall of anything similar to this happening. So to a certain extent, we're in a moment of what I think sociologists would call a political opportunity structure, where we have higher interest on the part of those with a felony conviction. We have higher interest on the part of in the public in politics, whether they engage in it or not, because politics can be very off-putting even on a good day. But this momentum is definitely there. And again, I don't have any knowledge of another historical moment like this. The iron is getting hot. People are striking at that iron while it's hot. And so that gives me hope with this as well.
Thank you. Another question? We have one back there.
Yes. My name is Christian Keller. I'm a student at the John Marshall Law School. My question is as follows. With the 19th Amendment in 1920, we saw not only an enfranchisement expanded to the female voter, but implicitly with that, we saw a right of women to serve on juries. We've seen this with every expansion of enfranchisement. And so my question is, if we see a guarantee of the right to vote afforded to those who are in prison, can and should we expect to see right to serve on juries afforded to prisoners at some point?
I can answer that like, they'd be removed for cause. I can see a lot of individuals removed just for cause alone before they even make it impaneled to a jury system. But that's an excellent point, because if individuals aren't registered to vote, they're never received a letter for jury duty. So we do have a great disproportionate individual, especially people of color, who doesn't even serve on jury duty. I distinctly remember doing my jury trial, there's only 4 individuals out of the entire jury pool, African Americans, 4 out the entire pool. And then all 4 of them were struck for cause. So you know, I have a predominantly white jury. And so that brought my interest into the history. But no, I could see the majority of individuals removed for cause, even if they did have the eligibility to right to vote, or even if they are registered. And that's just something that will have to be addressed through civil rights action in regards to they're not receiving the opportunity of engagement.
Yeah, I mean, my hope is that after in Florida, once we are successful with our rights restoration petition, the next challenge will be on what we call banning the box. And that is the policy where if you have a criminal conviction, even as old as it might be for many individuals, decades old, or for crimes that don't rise to the level that should bar you from even applying for a job, that we're going to have some rollback in terms of that policy so that people will at least be able to get through the initial screening process. It doesn't mean that employers won't have an opportunity to do a background check to make sure that this is the employee that they want to have on their staff, but it means that the felony conviction isn't an automatic obstacle to even making that first impression. So while I agree the other civil rights that come with restoration of rights, such as serving on a jury, are important, I think the employment issue, when I hear folks who say, and again, it's not a lot, as Professor Rivers was saying, a lot of people do want to get their rights to vote restored, but whenever I hear resistance, it's because, what does voting mean if I don't have a job, if I can't feed my family, if I can't pay for education? So I think you correct me if I'm wrong, but I think that's going to hopefully be the next wave of advocacy.
It is without a doubt. I mean, I faced that experience myself. Illinois championed that. Iman was one of the individuals that was responsible for pushing for that piece of legislation. So we do have ban the box. Unfortunately, employers are using background checks to get around that process. So once you get past the first interview stage where you present your resume, you have a phone call, and you get down into the actual physical interview, nothing is said, and they push this piece of paper in front of you. So would you be willing to do a background check? Well, of course you're gonna say yes, I don't mind. And then you'll be hired tentatively, as I was in many job opportunities, and now I get the phone call saying background check returned, and I'm looking at it like, yeah, I see it too, as well. And they're saying, well, thank you for applying, but we're not gonna hire you at this time. So they've been using background checks to deny most felons with applying for these applications. But I also want to share just briefly before I forget, in regards to the Prison Policy Institute, Peter Wagner presented an excellent work on gerrymandering. And so I would encourage all of you to look at that, because they actually brought action against the U.S. Census and challenged them to correctly define the definition of residency. And so the Prison Policy Institute has an excellent, I don't even know if to call it an article or journal in regards to their research information about gerrymandering.
It's a really big, complete website, and it goes by two names, Prison Policy Institute and then prisonersofthecensus.org. Those are both the same, and they have phenomenal information on there about this problem of prison gerrymanders.
So 2 plugs before we move to the other room for the reception. One is for all of you who care about this and want to do something about it. We are still recruiting volunteers for our March 20th election protection work for our nonpartisan voter protection program of Chicago Lawyers Committee, National Lawyers Committee, and other partners. Please see me if you're interested in that. We have attorneys, legal professionals, and others who will be at the polls and assisting voters in other ways, and we would absolutely love your help. And I also wanted to request if Jen from Chicago Votes can briefly mention the status of HB 4469 and how people can get involved in that initiative if they're interested.
Hi everybody, I'm Jen from Chicago Votes. So there's a bill that was drafted, HB 4469. It does 3 things. One, it turns Cook County Jail into a temporary polling location, so that election law will apply to the jail, which means potential machines in the jail is super important. 2, it gives a pamphlet, a Know Your Rights knowledge pamphlet that was drafted by ACLU and some of the lovely panelists up here. And so the whole idea is once you're released, you have a piece of paper that says your voting rights are stored properly. So the bill has at least 29 co-sponsors. We are pretty sure it's gonna get out of committee, which is awesome. And then obviously it'll come to a vote tonight. But we definitely witness slips filled out for it and just passing along the knowledge creation for it. And if you want to volunteer in the jail, do voter registration, all right.
Thank you, everyone, and thank you to our phenomenal speakers from across the country and across the city for joining us today.